Morning, everybody. My name is Eric Rohr. I am the national leader of the Board and Ladner Gervais Education Practice Group, and I'm delighted and thrilled to be here. I'm also a co-chair with Tony Brown of the LawWorks conference, and both Tony and I are absolutely thrilled and delighted that you're here. This is the 8th annual LawWorks conference. It's been extraordinarily successful. A number of years ago, well, 9 years ago, Tony called me and said, I've got this great idea. What about setting up a conference based around case studies and practical, hands-on fact situations and getting people immersed in the law and legal issues? And so this is how LawWorks grew and prospered. And it was actually modeled after a very similar type of conference that Sara Redfield, who's our keynote speaker, created and developed in Concord, New Hampshire at the Franklin Pierce Law School. So we're absolutely thrilled that you're here. And I just want to say a few words just to say we have an amazing day for you today, and just jam-packed with great issues and excellent speakers. We have an outstanding keynote speaker you'll be hearing in a moment. And I just want to say that I want to thank the Toronto District School Board for their awesome support in this. I want to thank the Toronto Catholic District School Board. Both directors are here. You'll hear from them in a second. OISE UT is, of course, a major sponsor in this, and of course, our firm BLG. And we're all on the planning committee together. So we have Tony Brown, Sharon Duffy from the Toronto Catholic Board, Ruth and Sue from OISE, Melissa from OISE, and this most recent meeting, Rory McGuckin's joined the planning committee from Toronto Catholic. So we're thrilled and delighted that we've got this amazing partnership. It's been very successful, and we put together this very compelling program. So without further ado, I just want to introduce two really great friends. I've known Donna Kwan for many, many years. We did Safe Schools together and lots of really practical hands-on things. And Donna taught me all about question and answers and how it's important to be very clear when communicating with educators. And so we've worked very closely together for many years. And of course, Angela Gauthier, I think it's probably now, I hate to say it, Angela, but over 25 years that I've been working with Angela in different capacities. In all different roles, and Angela at one time was the head of HR at Toronto Catholic and outstanding supervisory officer and now director of education. And it's just like I've got two really great old friends here to provide you with greetings from both Toronto Catholic and Toronto Public. Angela and Donna, please come up.
Good morning, folks, and thank you, Eric, especially for the emphasis on old friend, 25 years. Thank you. I really appreciate that. Kind of puts everything in perspective. But good morning and welcome, everybody, from both boards and from wherever you hail. We're really thrilled to be partners in this endeavor with Eric, Board and Ladner, and OISE. I've been on the planning committee for a few years in a row now. I've given that up to my friend Rory. I had heard him say in the background that was through no real choice of his, but it is a choice. He really loves doing it, I know that. It really is great. First of all, because I think we should all be passionate about the law and how it applies to what we're doing, because we can't function in a vacuum independent of the law, and that's just common sense, we know that. But, when you tell somebody that you're going to be spending the day with lawyers as you are today, I think the first reaction is, well, is everything okay or what's wrong? And yes, everything's okay. We're just being smart and we're being proactive and we're making sure that we're working within the right parameters. So it's a good thing to be here, and I welcome you all here, and I thank all of our folks in particular from TCDSB, all of our first year administrators that we're able to make it today. I think it's a great way to start. We have a strong partnership and we want to continue to nurture that. I think it's extremely important, both with OISE, who's a major educational partner, and with Board and Ladner, who's developed a tremendous amount of expertise in educational law. I know we call on them quite often, even though we both have in-house lawyers and legal counsel that we respect tremendously and know the systems well. It's always good to have an independent set of fresh eyes looking at things. That brings the provincial perspective to it. These sessions are really great. Based on case laws, you analyze and look at real history and how people have dealt with it, and then apply it to your reality. I think that's the best learning we can provide people with. Basically, I just want to say that the issues are current, you know that. We count on you and your dialogue during these exchanges to make it even more relevant to what you're living. So please do think and kind of delve into your personal experience and what you're going through now, and bring that to the discussion, to the dialogue. That's how you'll go back enriched and certainly empowered, and the capacity built to carry on your task. So once again, I just want to say thank you to our partners, and can count on us doing everything we can to increase and deepen the partnership. And I wish you all a wonderful exchange today.
Thank you. Thank you, Angela. Good morning, folks here. It's a pleasure to represent the Toronto District School Board. And I'm glad that we have Toronto District School Board as well as our planning folks involved in this conference. I know that they've indicated it's 8th year into it. I can say to you that each year it's important to build on the learnings of the past year. So I hope that we have a number of candidates here who are attendees of the past, because I think what is important is we have a strategic direction in the Toronto District School Board, 5 strategic directions. And the one that resonates with me the most is identify, disadvantage, and intervene effectively. In order to identify, disadvantage, and to intervene effectively, we all know that we have to know someone who is an advocate, someone who is willing to debate and challenge, and to also present cases and case law. And the fact that you are all here to debate, to challenge, and to question, it's important to move identifying disadvantage and intervening effectively forward. So on behalf of the Toronto District School Board, I would like to echo Director Gautier's comments as well, that we're very proud to partner with OISE and LawWorks and the 2 law firms that are here, and as well as the 2 boards, to really push the envelope of dialogue and conversation. I'm pleased to see that we have a good cross-section of attendees here, from educators to lawyers to others who are involved in the field of education. And it's very fitting that it's in this organization, Inspiring Education for 100 years, because law is about societal advocacy. It is about moving the conversation for a better citizen. So citizenship is very important to all of us. Citizen-centered leadership is important to all of us, and LawWorks supports this direction. So thank you, Tony, and thank you, Eric, and thank you to the planning team. Thank you.
Education in a turbulent world. I think you all will agree that this is a complex, multi-dimensional society that we're in, and you folks as educators are constantly on the receiving end of different demands. Your world is constantly changing. You've got demands, of course, from parent groups, staff, teachers, community partners, trustees, school administrators. I mean, it's a very complex environment, and there's a legal component to this, and that's why we thought speaking about education law in a turbulent world would be a very relevant and timely subject, and we got probably the best expert in the world today to do that. You're all in for a treat. Sara Redfield is a professor emeritus with the University of New Hampshire Law School. I've known Sara for many years. She ran the LawWorks Institute at the Franklin Pierce Law School in Concord, New Hampshire, and I went down for a number of summers with Marvin Zucker to speak together as a team, and it was just a great experience. And Sara runs a huge institute down in Franklin Pierce with educators and school administration from all across the US. So she is the preeminent expert in the US on education law, and we're so, so thankful that she's able to be here today. Sara is nationally known as both an author and presenter, and she was the lead author for the ABA section it's called the Litigation Toolbox on Implicit Bias. And she'll be speaking on bias actually this morning, and she's currently the lead consultant for the ABA project on achieving an impartial jury. And she earned her BA at Holyoke College, her law degree at the Northeast University Law School, and she's got an LLM from Harvard Law School. And Sara has a son who's living in Toronto working. His son has a girlfriend who's from Toronto, so she's got a strong, now a strong reason to come to Toronto. She's got a wonderful daughter, an amazing husband who's an economist and a farmer. I've been to Sara's home in Maine, had an incredible seafood special dinner that she cooked up, and she's just an awesome person and a great friend to LawWorks. So, ladies and gentlemen, Sara Redfield.
So good morning, everybody. And Eric, that is a little overwhelming, but thank you very much. I'm nowhere near the world's expert, but I have been doing this kind of work for quite a while. And I just want to take one step back before I start my talk and say for 1 second something about the Education Law Institute that we did in the States that Eric was describing, because I think the idea of that is significant for all of us. The idea was, just as this meeting is, an opportunity to bring lawyers and educators together to talk to each other in a non-confrontational setting. And before starting that, each group of lawyers, each group of educators, the teachers union, the school board club, everybody met separately and they all plotted, I guess, for their strategies, and people didn't talk together. And so that was a neutral kind of meeting, and it turned out to be really effective. And I took away one lesson from the very first conference that I always try to share when I talk to groups like this. There was a panel, just like this, and they were all talking about, I don't even remember what, some kind of liability, all lawyers, and they're all disagreeing with each other. You know how we love to say on the one hand and on the other, right? We love to say that. And a school superintendent way, way back there put up his hand and said, oh, for goodness sake, what am I supposed to do every day? Right? And there was silence for a minute on the panel because they were just dying. You could see it to say, well, on the one hand and on the other. Right? You could see their faces. And then the fellow one of the attorneys who was then head of the New Hampshire Human Rights Commission said, you're going to do what you think is best for the child in that minute, and we are going to defend you later. Right? So I thought that was a very telling piece of advice, because no matter how many cases we all teach you about, no matter what you learn about the law of search and seizure, no matter what you learn about cyberspace and bullying, in the minute you really are not going to get out your notebook from the law conference and say, now what should I do now? You're not going to do that. So I like to tell that story because I like for folks to have that perspective, and it's not really part of my real presentation, but I wanted to tell it, and I was particularly struck by your opening remarks, both of you, in terms of the value of coming together and talking together, and I think already what I have to say will resonate. So that's just the beginning. So of course I want to thank Eric for inviting me, and I'm glad to have a chance to see Tony again. But Eric, I have to tell you that I've been agonizing since you invited me, right? So I had this recollection that you invited me to talk about the view from the States, right? Sort of review what happened in the year. And since you invited me, I've been putting little notes to myself in my folder. This is what I'm going to talk about when I go to LawWorks. And then, of course, it came time to pay a little more attention to putting my presentation together. And I said, oh, that's not my title. Oh, well, my goodness. Now I might have to review what I've been putting in my folder. But as I looked through my folder, I felt like your title was way better than what I had construed it as, in the sense of we are living in such overwhelmingly turbulent and disturbing times. So your title was better, but then I got even more depressed. Right? Because as I started to look through my materials, I felt like, well, this isn't my usual talk. I sort of stand up and review 5 cases and sit down. And if I'm depressed looking at this, how is it I'm going to convey what I see as the sort of trends to the audience? So I'm beginning my talk by apologizing for what I think will be a fairly depressing talk. And also saying, I was depressed first. I've been depressed longer than you. Getting this together. So I can't really help the subject matter. I just can't help the subject matter very much. And I'm hoping there's going to be time for there to be some dialogue. I also want to say that my experience working with Eric and Tony and Marvin and coming here other times and working with some other folks here in Canada is that I harbor this little hope in me that you're doing better. You know, that you are all doing better with some of these issues than we are, and that we have a great deal to learn from you. So I'm giving you the perspective from the States, mostly from the Supreme Court of the United States, but I frankly think your perspective may be better. And I'm interested in hearing all about it. I mean, just in, Donna, your opening remarks about the identify the disadvantage and intervene effectively, that would be a great motto for everyone. Right? It is not the motto for all of us in the States, far from it. So that's my sort of a little bit emotional, not my typical presentation, but my little bit of feeling background for some of the things I'm going to talk about. So as soon as I figure out how to move the slides forward, I'll be good. Okay. So as I tried to put my talk together, I was thinking about the number of topics I wanted to talk about, which are many, right? And where did I slide with my pictures? Sorry. There you go. Which are many. And I started to think about them in terms of Malcolm Gladwell's book, where he talks about thin slicing. I don't know if you know this book, but where you have a little bit of knowledge, and you take that little bit of knowledge and it expands, and often it helps you make a really good decision. Of course, not always. But, and he talks about it in terms of art experts in the beginning of his book. And so as I was thinking of the topics, I said, well, really it's thin slicing. It's taking a little bit of information about each of these topics, talking about it and seeing if we can come up with some unifying theme. So that's my plan. I'm going to talk about a few different things. Whether I come up with a unifying theme remains to be seen. Not that I wasn't prepared for this presentation. I'm just not sure that I can do it. So these pictures are illustrations of some of the things that I think are relevant pictures in terms of thin slicing and in terms of topics I'm going to talk about. For us in the States, I'd say race is the biggest one. Race and ethnicity, but there's also violence, these beautiful little children, other children from Newtown who were killed. All of these the little tweets and all significant. I want to point out about the children and also about the banner above it about Harper High School. So 20-something children and teachers were killed in Newtown. That same year at Harper High School, which is a primarily black high school in Chicago, 29 children were murdered. Not all at once. And so that framed a little bit of my thinking when I said for us in the States, race is really the issue. But I'm going to talk about several issues as we go forward. So consistent with, oh gosh, Eric, you shouldn't have asked me to do this talk because now I'm depressed, I tried to get myself a little perspective. So I thought about two things that are particularly relevant to history in the States, just try to bring myself back to some ground that maybe could frame what we're talking about. And these are two illustrations of it. The first picture is Dr. Clark, who tested young black kids at the time of Brown versus Board of Education, and they reported to him they would choose the white dolls. I'm sure you're familiar with this experiment. It was the first time that the social scientists were accepted in the United States Supreme Court. Their evidence was accepted and considered in a Supreme Court opinion. The other one, I illustrated it with the New England Primer, is, I'm not sure you'll be able to read this, is the Satan Deluder Statute, which was the formation of the first public schools in the United States, where the people in Massachusetts decided they wanted to delude Satan. And the way to do that, you all know this, have education. So this is the first mandatory public education in the state. So I sort of had these two things in background for myself as, again, as perspective. We require students, we require children to be educated, it's mandatory. And then the Supreme Court of the United States said that it was important, and that if the government was going to provide education, it had to provide education fairly. So that was in the 1600s and the 1950s, and now we're in 2013, and we have to, I think, ask ourselves how far we've come. So my first topic is race and ethnicity, and I guess what I have to say here is, for us in the States, we are faced with what can only be described as enduring and intransigent disproportionality in just about every part of our education. So, I can do hours worth of talk on this, but I'm going to just give you 2 examples and ask that you reflect and see if they're the same here, or if not, I hope not, and if so, or if not, I hope there's talk to be had about how to improve things. So the court in the States continues to hear questions about diversity and affirmative action at the same time that we have these huge disproportionalities in our achievement gaps and all those kinds of things. And this is a big piece of the Supreme Court's jurisprudence in the United States this past couple of years. Is it okay for public institutions to consider race as a factor in assigning students to schools or admitting them to universities? And I've given you sort of a series of cases that have talked about this. Actually, they started way before this in a case called Bakke, which the University of California had a quota for black students for their medical school. But we've moved beyond that to the current day, where the Supreme Court of the United States has said it is still okay to consider race in admitting students to school, so long as, and that will be considered under our Constitution a compelling state interest, which is what justifies race being considered, so long as the way you do it is narrowly tailored. So this is really, and this term, they're hearing arguments in this top case, which involves a referendum in Michigan, which would have precluded considering race in admission to schools. So for us in the States, this is an issue that is not going away. Okay, so these are university cases, except for this bottom one, parents involved in community school, which is a high school case, where the Supreme Court rejected the Washington State allocation based on race, where the city tried to, they said if you're a high school in the city and the city's population area is 50% black, then your high school should be 50% black, whatever that proportion is. The Supreme Court rejected that and said it wasn't narrowly tailored enough. And the beat goes on. So these cases are going to continue to come around at all levels. And we're going to, I think, continue to say, we value diversity. That'll be the first thing we say. And then there'll be a comma, and then there'll be a big but, right? But don't do it this way, don't do it that way, don't do it this way. So when you think about that, it begins to explain why we should be so plagued as we are by this disproportionality. We are separated, we treat our students differently, and the results are different. So I just quickly show you a couple of examples here. This is, and I'm not sure you can see it from where you're sitting, but these are the achievements for students with disabilities, without disabilities in reading, and students by color. And you don't have to see it to get the basic message that whatever we do, we are not treating, as Donna said early, disadvantaged kids equally and fairly. We are not. And the results are telling. We are not graduating. We graduate about 75% of our students in the States from high school. That's all told for Black and minority kids, Black and Hispanics, and American Indian Alaskan Natives. It's more like 45%. So we are really not doing a good job. So when I say that race and ethnicity is an issue for us, it's a really big issue. And it plagues our entire education system, and we surely do not have the answer. So, Tony, Eric, you invited me here. I hope you weren't expecting any answers to come from me. We don't have the answer, despite years of trying, right? And the Brown versus Board of Education decision was in 1954. So that's my sort of first slice in my thin slicing that topic. And I start with it because I think it's the most troubling and the most predominant in consideration about education in the States. And But there are other topics, and I'm going to touch on a few of those as well. So one of the big ones for us, and I think for you as well, is free speech, right? We have the First Amendment to our Constitution, which guarantees speech rights to everyone, including students. Students do not, as the Supreme Court has famously said, leave their constitutional rights at the courthouse door, right? So students have free speech, and these questions and these issues, again, continue to plague all of the courts in the United States. If you go search the education law indexes for free speech, you get a large number at every level. And remember, those don't count the cases where disputes are settled out of court, right? So large amount of our legal time is consumed with issues of speech. And so here I've illustrated a few of them for you just with the pictures, and I'm going to talk a little bit about them as well. So I'll start with the headdress. So there's always a fight in the States about whether Native American team names, symbols, whatever, are legitimate mascots for various teams. This year, the state of Michigan's Human Rights Commission complained to the Office of Civil Rights, which is our federal agency that controls civil rights investigations and litigation, about the Michigan teams using various pieces of American Indian native art or insignia. The Office for Civil Rights rejected that claim. So this was kind of a big decision. Michigan said the stereotypical impact of this was huge and should be just removed. And the Office for Civil Rights said that the state had not proven the injury, so they rejected the claim. The next one, it says Daddy's Little Redneck, the T-shirt, and it's a case out of the South, oh, what a surprise, southern part of the United States, a long-running case dealing with a young woman who year after year wore equally inflammatory Confederate-oriented T-shirts, and time after time was told to turn her T-shirt inside out, change her T-shirt. One time she was suspended. That was the ground for years of litigation. So she finally lost her last round in the circuit court, which is the next down from the Supreme Court in the state, and the Supreme Court rejected the case. So she's finally done litigating about it, but the issue is not done. I should have done the search for how many cases we had about Confederate flags, right? Because this is just an issue which does not go away, but it's symbolic of students' desire to reflect where they came from, reflect what they believe, whether it's by, whether it's by wearing a T-shirt with a Confederate flag, or taking a banner to the football game, praying when our Constitution says we don't pray at school, but finding ways to pray at school and to go on litigating over and over and over. And I think that was the other thing that struck me as I was getting ready for this talk. Maybe I could have given the same talk 8 years ago, right? Because we don't give up, that's for sure, litigating these issues. We feel strongly and passionately about them, and we love to litigate. We love to litigate. And we love to say, I'm going to take it to the Supreme Court. And we do, not everybody, but we do. So speech is really an area of the law that is always with us, and I would say changing a little bit. And I'm going to talk a little for a second about that. This last picture is of a young woman. She's actually a Canadian young woman whose picture I happened to find. And I'm not sure I can remember what town she's from. No, I guess I didn't write it down. Anyway, and she's holding an I Love Boobies bracelet. You all know about these bracelets? Yeah, anyone who doesn't? Okay, so these bracelets, you don't know? Okay, so you can see what it looks like. It's one of those rubber band bracelets that kids are wearing, and the bracelet says, I love boobies. And depending on who you ask, the point of the bracelet originally was breast cancer awareness. And though some school principals obviously felt otherwise. And so the case that that may go to the United States Supreme Court is about some girls in Pennsylvania who wore these bracelets and who were then suspended from school. So you can see, right, all the issues that are coming to play here. So it's worth thinking about this case just in terms of the various interest points that come into play. It's been litigated right up through the federal court system. There have been lots of hearings. The way the system goes, you start in the district court, then you go to the circuit court, then you try, you're not by right, go to the Supreme Court. At the circuit court, you can have an original hearing, and then you can have what's called an en-banc hearing, so all the circuit judges have to hear you. It's been everywhere, this case, right? And nobody wants to quit. Nobody wants to quit litigating. So they're trying to get what's called certiorari to go to the United States Supreme Court with the case. So what's it all about? You know, how hard is this? These were folks in your school, and would you all allow these kids to wear these bracelets? Yes, or how many of you would allow these bracelets? Not so many. Not so many. And how many of you wouldn't allow them? Or how many of you are just remaining silent here? Yeah, I like your types. I really like your types. Okay, so that's probably how the states would break down too. I mean, that's probably how administrators would break down. Though I would say more people would have had their hands up for would not allow. Would not allow. And that's why it's such a litigious thing. So what's the standard? In the states, we have 3 old cases about student speech, one of which is Tinker, which involved kids in the Vietnam War area wearing black armbands and being suspended from school. And the Supreme Court saying that that was not okay, that those kids had a free speech right, they weren't disrupting anything, they should be allowed to wear those armbands. I mean, don't you just sit here and think, oh, for the good old days when all we cared about was black armbands, right? You know, those days are gone. And then they're called a trilogy. There are a couple of other cases, one about a school newspaper, which sort of stands out there on its own. The schools can control the content of a school newspaper. And then the third one about a lewd and lascivious speech given in an assembly. And the Supreme Court, God love them, printed the entire speech in the opinion. So you can go decide for yourselves if you think it's lewd and lascivious. I really don't. But anyway, and the Supreme Court said, okay, schools don't have to allow lewd speech or obscene speech. Surely they don't have to do that. So that's sort of where the law stood in the state till a few years ago. The 4th case got added to the trilogy. It's most commonly known as Bong Hits for Jesus. It's really called Morse versus Frederick. But kids had a big banner that said Bong Hits for Jesus, and the Olympic race torch was coming through town, and they took the big banner out on the street outside the school. And the principal said, off, and went all the way to the Supreme Court, which said, oh, if it's about drugs, you can regulate it. That's one of our big principles in the state. We don't really have a constitutional amendment that says that, but we might as well, because if it's about drugs, you can do anything you want. That's how I look at it for the schools, right? If you do, or even better, if you say it's about drugs, you can do anything you want. So that's the background for which under which the court's got to decide whether these bracelets are free speech, entitled to protection, or whether the school can intervene. So those of you who said you would say no, what are you thinking? You're going to just say, oh, it's disruptive, right? That's what you're going to say. Or you're going to say it's lewd. Also a possibility, right? And that's exactly what these school administrators said. And, but the Third Circuit, which is the highest court that's heard it so far, said no, it may be lewd, maybe, but even if it is, there's a political and social message, and so it's entitled to protection under the free speech law. So this would be a big change in Supreme Court precedent if the Supreme Court agrees with that. Be a big change. Political and social speech, even if lewd, will sort of rise up to more protection. And when you think about it, I think about it in terms of my own kids. I'm sure you who have kids in schools right now think about it. Their world is so different. You know, lewd doesn't really mean much anymore, does it? I mean, these are kids who are sending nude pictures of themselves around on their phones. You know, for them to think the word boobies is lewd is really probably, you know, it's what I might think, but not what they might think. So I think we're seeing a little bit the courts begin to respond to the modern era. But another part of my talk is, or another piece of my message, a different kind of slice is, the courts are way behind, right? The courts are way, way, way behind. So this is a case to watch in the States. I guess it's a case to watch here, since kids are being suspended in Canadian schools as well. I don't actually know what I think about it. But, draw your own conclusions. Maybe now that you've heard a little bit more about it, you'll feel have some different perspectives. So I sort of put this list up here just to remind us that we've gone from Tinker, the case with the black armbands, right, to Twitter. And the court is still at Tinker, right? The courts in the United States have to go, because they have to follow precedent, right? They're not free to just make up the rules. They have to follow their precedent. So the courts are still going back to Tinker, seeing if there's a threat of substantial disruption, and trying to decide Twitter, right? It's like incongruent, right? They're just not able to keep up. And I guess the other thing I would say about this is, for a long time we had the precedent, I'm not going to say it was the law, that things that happened at school were within the school's purview, right? And things that happened away from school, so-called off campus, were not. So if I went down to the parking lot and I was chatting with Tony and I said some really obnoxious things about the principal and the administrator, and maybe I got in a fight with another kid over it, and a lot of bad stuff happens, the school probably isn't going to have much to say about that in the States, because it's off campus, right? If I did it on campus, then of course I could be suspended or otherwise punished, whatever. So that used to be the state of the law, but how can it be the state of the law today? It can't. Everything happens off campus, right? And on campus, right? I mean, who's here without their cell phone? Right. And let me tell you that if you were 10 or 15 years younger than any of you in this room are, you would also have your cell phones here. We've reached the tipping point on cell phones, right? And kids and tweets. Text is the new everything. It's the new email. It's the new talk. And here sits the United States Supreme Court thinking about black armband kids coming to school, right? So it's a disconnect that I think we're going to have to come to terms with, but none of the internet cases, none of them have yet made it to the Supreme Court. So in this context, in the school context, I mean, there's plenty of internet technology law in the States, but not, they're all still at the circuit level, and every time we think one will go, it doesn't quite make it. So I think this is an area where the court has to face up to the difficulties and give schools some guidance. Meanwhile, you're all going to do what's reasonable. And if you're in the States, you're going to be thinking about, did this speech, wherever it took place, come to campus and cause disruption? So if I'm putting something really nasty out on the internet about one of you, and it never comes to school, probably the school's not going to have jurisdiction. But the likelihood of that is pretty small, right? Everything's everywhere. So we have lots of lower court cases about all of these things, and I actually had a whole slide later about cyber everything, right? And it's very troubling. It's very troubling as a parent, it's very troubling for teachers, it's very troubling for schools, and I have to say, in the state schools do their level best. Legislatures do their level best. We have lots of anti-bullying laws, lots. We have lots of school policies, lots. Are we having an impact on this kind of behavior? Doesn't look like it, right? Doesn't look like it. And so this is just a summary of some of the points I just made. Kids are different. They are oblivious. They think nothing of sending nude photographs to each other. Nothing. And, we have some school administrators in Pennsylvania worried about I Love Boobies bracelets, right? That school board just recently voted to appeal that case, right? To try to get their lawyers to bring it to the Supreme Court. One lone dissenter on the school board who said, we fought this, 20, maybe 30, I don't know how many times. I think it's time for us to quit, right? But 7 others want to take the case to the Supreme Court. So, but here is where I think the real issues are, way more harmful. And some of these pictures are text that folks send. And how many of you know what Snap is? Is it Snap? Yeah. Yeah, Snap and Poke. Anybody know Snap and Poke? Few. Okay, so Snap and Poke are ways that you can send me your picture. Don't send your new picture, any picture. No. You can send me your picture and it disappears off my phone, right? Except we all know that it only disappears if I don't really quickly save it. So I can take a picture of the picture you sent me and then it stays on my phone. And then, of course, I can send it to all your friends, to your email list, which is one of the cases in the state. The disgruntled boyfriend sends the nude picture of his former girlfriend to her entire email list, which, of course, includes her grandmother, right? You get it? Nice. So this kind of, and I think the advertising for this Snap and Poke misleads folks to thinking it's going to disappear. But, of course, it doesn't disappear. Nothing disappears. This is the message I sort of pound into my kids' heads over and over. Don't put anything out there that you don't want to read in the morning paper. But kids are oblivious. And so here I think is where the rub is going to be. Kids are going to be oblivious. School boards and legislatures and city councils and every other governing entity is going to try to fix it. And kids are going to be oblivious. So for me, this is not a question of law anymore. I mean, there are cases, there are people litigating these questions, there are people litigating about bullying and suicide and all these painful results of some of these things. Cyberbullying, destroy your life, literally and figuratively, right? People are litigating, but I don't feel like the law holds the answer. If we can't reach these oblivious kids so that they understand the impact, then we can litigate all we want. And law enforcement folks in those states are coming to see this, and maybe that's happening here as well. It used to be then cyberbullying complaints went to law enforcement, to sheriffs, local sheriffs, police departments, and they would investigate. First it was they didn't pay any attention. Then they got to the point they would investigate because kids were killing themselves over it. It was not a small matter anymore. And now they're getting to the point where they try to intervene and negotiate and change the dynamic. Not so much do they try to arrest a kid, but they try to change the dynamic, which I think is hopefully going to bring about some improvement. Otherwise, this kind of bullying is a felony in many cases, involve child pornography. The bullier, the one who sends the text with the nude girlfriend to the grandmother, that kid went to jail. And he is a sex offender, and he will be a sex offender for the rest of his life. So, there's a lot of layers to this, all of which, as far as I'm concerned, hurt kids. So, I don't think we have, in the States, come to a way to fix it, but I guess I would have to say we're working on it. So, and this is just a sample of the headlines about this, because I really, it was part of the reason I got depressed doing this presentation, right? I mean, look at this, suicide after suicide is unacceptable. It's unacceptable. And those of us who have children, my own daughter, when she was 16, just sort of stopped talking to us. So at that minute, right, parents, oh my gosh, what are we going to do? We didn't do such a great job, but at least we noticed. We noticed she wasn't talking to us. We noticed her friends weren't coming around anymore. But when you read these kinds of headlines, all parents and all teachers, every one of us has to be more on notice than I think we have been in the past. So school discipline continues to be an issue for us, and I'm sure for you. No matter what you do, it's the wrong thing, right? Yeah, got that. And no matter what you do, probably it doesn't have any effect. Maybe it does, maybe it doesn't. For us in the States, discipline has taken on an interesting, back to the racial slice perspective. Our Office for Civil Rights, for the first time ever, released a database called the CRDC, Civil Rights, I'm not going to get the whole thing, the Civil Rights Data Compilation, I think, CRDC. Made it public, in which they, for the first time, published in one place the relative discipline treatment of kids based on race and gender. So, having the data is really a significant thing. So that data, not surprisingly, showed that Black and brown kids are disciplined way more often, way more severely than white and Asian kids in the States. And again, not surprising to me, but clearly demonstrated in the data. So discipline has become a big issue for us, and there's a lot of talk in the States. It's become part of our national vocabulary about the school to prison pipeline. And by that, it's a shortcut for explaining that kids are suspended, kicked out of school, and end up in prison. And there's a lot of data to support that pathway, the fact that that pathway is happening. So it's, again, a really troubling racial disproportionality and a really troubling result. I mean, I've always found it sort of incongruous that if we want to discipline a kid for misbehavior at school, the way we do that is to kick the kid out of school, whether we kick the kid onto the prison pipeline or not. So it just feels a little off that suspension is to take away the opportunity to educate, right, or be educated. So, we have that sort of ongoing, how am I doing this? The slides are moving without me here. Okay, all right. We have that ongoing issue about discipline that's haunting us, but we also have, and I think this is a plus, that the civil rights folks have put the data out there so we can study it, so we can figure out what's triggering what. And again, I feel like it's going to turn out to be less law to fix this, and more educators to fix it, to pay attention to it, to see if this is a pattern for them and to try to change it. And we're starting to see some of those agreements. Broward County, the biggest county in Florida, just agreed to a new discipline policy focused on fewer and fewer suspensions. So I think that's a good step forward, not because of a lawsuit, but because of the data that they had to look at about their county. So, it wouldn't be a talk if we didn't talk about money, right? It just wouldn't be a talk. So for us this year, President Obama asked for 71 or $74 billion for just the discretionary programs for the United States Department of Education. So it's a very big number, right? And I think he'll get it. And the Department of Education in the States, if you go look at their website, will spend it. Right? They'll spend it trying to do what you said at the beginning, treat individuals who are disadvantaged fairly and bring them along. That'll be part of what they're trying to do. A large part of that money goes to what we call Title I, which is for disadvantaged kids, poor socioeconomically disadvantaged kids. Another very large part of that money goes for special education, where the federal government committed years ago to paying 45% of the cost for special needs kids, and now is paying nowhere near that and never will, but still a large part of that money. And then a large part goes to student loans, but it's still a very big piece of money. And so again, sort of why I was feeling depressed putting this talk together, I have to look at that very big piece of money, right? And I don't begrudge that money, and I don't begrudge the money my state spends on education or my town. And ask, well, are we getting our money's worth? And I have to say no. I mean, my children, my privileged white children, they got their money's worth. All children, I don't think so. And that's a pretty discouraging sort of state as far as I'm concerned. Well, we talked a little bit about this, cyber everything. I think it is the wave of the future, dealing with cyber everything. And it's at I'm just going to hark back to it one more second. One of the most disturbing cases I thought in the States was the webcam case. You know this one? Where the school, it was in New Jersey, where the school, Robbins versus Lower Merion School District, where the school had computers for kids. We all think this is very progressive, don't we? Yeah. Every kid had a computer. Every kid was allowed to take the computer home. Very nice, right? And those computers had webcams in them that when you opened them at home, they filmed what you were doing. You got to ask yourself, what are these people thinking, right? Or not thinking. So, to me, you juxtapose that, the school's use of technology, and then, of course, it was transmitted wirelessly back to the school, whoever, those, I'm not going to say it, people who were watching this, But eventually they got found out. So that's an example of the school's misuse of technology as well as the kids' misuse of technology. And it is, as far as I'm concerned, the trend. And we will see more legal cases over it no matter what, right? No matter what. And then, of course, this one is really, violence is just really overwhelmingly disturbing. I started out with the pictures of the children in Newtown and the banner because you couldn't find, it's interesting, you couldn't find 29 pictures of the kids murdered in Chicago. Those iconic pictures of those children in Newtown, they were everywhere, everywhere. You couldn't get away from them, and you probably still can't. But I couldn't find the pictures of the black children murdered in Chicago in larger numbers. So the violence is just overwhelming. It doesn't seem to have an end. We don't seem to have a way to control it. As you know, I'm sure, I don't have to tell you this, we certainly can't agree on gun control. So it's just overwhelming. At the same time, there's a lot of litigation about pieces of this, right? Searching is a big topic of litigation in the States. Can we bring drug-sniffing dogs into your classroom to search your pack after you've left? Is that a legitimate search? The answer is yes. It's a big topic, all kinds of issues around searching. And a growing topic, which I'd be curious to know if is the topic here, is the use of school resource officers. How many of you have police in your schools? Yeah, so in the States, pretty much every hand would be up now. Big cities, small towns, hands would be up. So this causes a lot of interesting dynamics, right? For us in the States, if you're a policeman, you have to have probable cause to search somebody, which is a legal standard, and it's pretty high. But if you're a school administrator, hey, go for it, right? I mean, within limits, you're not allowed anymore to strip search a kid for an ibuprofen, but anyway, so we do have a few limits, but basically, within reason, leaving out the strip searches, which we continue to do, mind you, which we continue to do. There's a new case coming up where a principal strip searched a kid for $20, right? Not even a potentially maybe drug, like ibuprofen, right? I mean, so never mind that. I'm showing my prejudices here. Okay, so we do have school administrators who can search. So what does that mean? If you, the school administrator, want to search her, and I, the police person, am there, which standard is it? Is it the standard for the police, probable cause, higher standard, or is it the standard for a school administrator? And if you take custody of her, whatever that might mean, you bring her to the office, you close the door, do you have custody of her? If the police officer is with you, do I have custody of her? And if I do have custody of her, do I have to give her Miranda warnings in this day? You know, you have a right to remain silent. You all know this from television, right? Okay, so you can see where the problems are going to come. And we're going to be litigating these issues a long, long time in the States because there are too many places where roles cross and it's not clear. And for us, if you search me illegally, then whatever evidence you get against me, you can't use. It'll be suppressed later. So an illegal search in a serious case can ruin whatever discipline is you're pursuing, either in the school or criminally outside the school. So again, lots of problems, lots of things. And the one thing I would say is this, that like I said about drugs earlier, if it's about drugs, you can do it. If it's about guns, you know, if you can show that what you're doing is looking for a weapon, you can do that too. I mean, that's not the way the law is written, mind you. That's not, no court says that, but if you read the whole body of law about this violence, you see it. And for us, you see it in ebb and flow. So after the Columbine shootings, any kid with any possibility of any violence had no hope. You wrote a poem that had something about violence, you could be suspended. The heck with your free speech. We didn't remember free speech after Columbine, right? Just, that was it. Then years went by and kid free speech became more in vogue and we couldn't really remember Columbine and we started to say free speech is an important release for kids. Maybe we shouldn't suspend them. But you know, now we're back. So for us, that's sort of violence piece comes and goes in the courts because, as one judge once reminded me, Ms. Redfield, we do read the newspapers. Yes, sir. So, the courts are not immune from the kind of publicity that you all are watching. So it struck me as I was preparing for this that my whole talk was going to come to its end, and I hadn't talked about most things that we usually talk about at these conferences, right? I didn't have curriculum matters. And for us, curriculum, there's big issue around having a core curriculum, uniform around the country, big controversy about that. There's big issues about testing under No Child Left Behind, lots of controversy about that. And so I sort of came to the end and I said, well, geez, how did that happen? The sort of classic topics didn't really rise up to have the first slides, right? And so I reflected some more on where I started with my perspectives and on the title, which you gave me, about turbulent times. And so in these times, even though we in the States continue to fight about all of these things, believe me, we fight about all of them in the courts, and we litigate about them, and we all say, I'm going to take it to the Supreme Court, right? We are not spending the time as a society on them just proportionately that we are on these other kinds of issues that consume us, even though and lawyers as well as educators, even those other issues are more, I think, for educators. The law just isn't there yet. So having said that, I'm going to just end with one thing that I think is probably relevant to your lives as well as ours. And this is an area where the law in the United States is changing. So for a long time, until just this year, we have held to the principle that we, as educators, did not have a duty to protect against a third person. And this came actually from a case that wasn't a school case, it was a social service case where the social workers didn't take, called DeShaney versus Winnebago, where the social workers didn't take a kid out of his home and then the kid was permanently, irretrievably brain damaged. So that's where the principle came from, and the courts have stuck with that for decades now, and there have only been a couple of exceptions. One where the town or the school takes control of you, so if you're in a state facility, that's an exception, or where there's some other evidence of a duty to protect. And so for the first time this year, there's a court that has said, we found a failure to protect as a due process violation because this school was so, deliberately indifferent. And the facts of the case are, this is the father and the son here from the case. The little boy is in school. Obviously he's older than this. I think he was 9 at the time of the case. The little boy is in school. His mother is deported. His mother calls the school and says she's been deported. Reports this to the school. The father has custody. One day some other person, but of course the school doesn't check on who it might be, calls and says that she's the mother and that someone else will be picking the little boy up, and the school allows it. And the someone else kidnaps the kid and takes it to him to his mother in Mexico. So this is the father without the kid, who, of course, and I don't know, I made a slide of this, I intended to. Oh no. Okay, so the school policy on this is absolutely clear, absolutely in writing. Your kid will not be released to anyone who's not on the approved list, right? All your schools have this policy? Most heads are nodding. Well, if you know it, you should. Okay, so this father won a damages verdict for $2.8 million. So it follows very closely on a case just the year before called Doe versus Covington, which was an even more disturbing case where this child, Jane Doe, is released from her school to a fellow named Keyes, who comes in and says he is her father. On one time, the child is signed out to him, and it's written on the form mother, right? So he is neither her mother, nor her father, nor anything else. And he takes that child out and he rapes her repeatedly. More than once he does this. And the school allows this to happen. Let's just say he wasn't on the list either. Okay, so, and in that case, the court refuses to find a constitutional due process kind of claim. Now, sometimes you have other claims. I don't mean to mean there's no relief for these kids and their families, but this is a beginning. I mean, I think we're going to see a change as we see these really, really egregious situations. When I read the Keys case, I said, okay, this is the case. This is the one where they're going to change this. But no. But maybe this is the case. This one hasn't gone to the Supreme Court yet. So, so there you have it. So I wanted to, it's not a cheery note to end on. It's a note, though, in terms of, I think schools, this is an area where schools can act to protect. Some of the other areas I think schools can act to educate. So I don't want to end up totally hopeless, though I'm not going to forgive you right away for how down I felt doing this. Things are tough. It is a really turbulent world, and for our children, even more so. Even more so. I mean, I'm glad my children are now 20 and 27 years old, that they're not little and going to school now with all these, they have their own issues, don't get me wrong, but with all these same intense issues to fight. So I guess that's the end of my talk. Not exactly a cheery note, but we have a few minutes, and I'd like to, ask questions if you want, or comment. And I'm going to be here all day. You have me assigned to at least 4 other things. I'm going to do a talk later on bias, which relates to a large part of this race disproportionality stuff that I talked about. So I'm going to be around, and I really would be grateful for the opportunity to have feedback from you about what you see here that may be, I hope, better than what I see across your border.
Hi, everybody. How do I do that? I don't want to break it. Good morning. Wow, I could just sit here and listen to Sara all day. I mean, look at the breadth of issues that we've heard about over the last 45 minutes or an hour. And, if you're not in the audience sort of nodding your head saying, yeah, that's coming, then you must be in a different kind of school that I'm used to, because there's so much overlap with what we see on a daily basis in our schools. It may not be the same scale, but the trends are unquestionably there, and we have so much to learn from the experiences south of the border, both in terms of what to do and sometimes what not to do. Some of these messages are extremely sobering. Sara started her talk by mentioning the superintendent at the back of the room and said, what am I supposed to do with all this law? And I think that's certainly one of the most important messages that we've heard today, that in fact it all really goes back to the best interest of the child. You're in the moment, you have to use common sense and draw upon your experience. So lastly, I would just simply say that the United States does have a lot of problems with guns and violence, but you don't have Rob Ford. And on behalf of the participants here today, I would like to extend my heartfelt thanks to Professor Redfield for coming up and giving us this amazing overview of all of the legal issues that are facing schools today. Thank you.